Joining me now is former Acting U.S. Attorney General Matthew Whitaker. And it's great to see you. So many questions for you. First, I do want to get your initial thoughts on the Supreme Court's ruling yesterday.
Well, the Supreme Court got it right, and this is the thing: is I'd rather have them get it right than hurry, and that's what essentially Jack Smith and the judges in these cases, except in Florida, have been trying to do, is rush this case and these cases to trial before the election in hopes to impact the 2024 presidential election. I think Chief Justice Roberts did a really good job in explaining why getting it right is more important than any near-term election impact. But this is what happens when you employ novel legal theories. Jack Smith and all of these prosecutors overreached, just in the hopes of getting Donald Trump convicted so that it could impact the election. And, watching Joe Biden's remarks yesterday, it just struck me that a lot of their strategy in winning this election was in these legal cases and hoping these prosecutors could succeed with these legal theories that just, again, had not been tested, and the Supreme Court smacked it down pretty solidly.
It did seem that the president's remarks last night it was a political speech at the end of the day from the White House. But I want to go back to this decision, because what I think is being missed is the actual opinion from Chief Justice Roberts. And look, he did say a president may not be prosecuted for exercising his core constitutional powers, and he is entitled at a minimum to presumptive immunity from prosecution for official acts. But Roberts also added in this decision that the president enjoys no immunity for his unofficial acts, and not everything the president does is official. The president, quote, is not above the law. Then you hear Sonia Sotomayor spend 30 minutes, by the way, a half an hour in her dissent. And she goes on to say, with fear for our democracy, I dissent. The president is now a king above the law. I mean, I don't think I've ever seen the Supreme Court it was almost a polarization yesterday.
Yeah, Cheryl, and you make a really good point, because this certainly did not exonerate President Trump or any future president from their acts. All it does is essentially create a process pre-trial, before the jury hears it, to decide kind of the three buckets, whether something is a core function official act, whether something is broadly an official act and given presumptive immunity, or, to your point, whether it's a private, unofficial act and therefore with no immunity. And I really think that the Supreme Court was very careful in not prejudging this and sending it back to Judge Chutkan in D.C. to decide which of those three buckets, the alleged conduct that Jack Smith includes in his indictment, of where that falls.
But also, too, and I wanted to ask you about the Jack Smith case, because obviously this delays it. I mean, because that judge, Chutkan, she's not going to see this for, 32 days or 34 days, if I'm not mistaken, even to re-blast up this case against Trump. So that seems to be kind of on the side. The other issue here is this New York case, because sentencing for Donald Trump here in New York is July 11th. But now his legal team, and I want to get your take on this, now they're saying, okay, this SCOTUS immunity ruling, they're using that as the justification to get that case in New York thrown out. What are the chances of that, in your opinion?
Well, I think it's a really interesting argument, because in the opinion, Judge Roberts did say that if it's in that bucket of core constitutional functions, therefore fully immune, that cannot even be brought in as evidence. And remember, a lot of that trial, I was up there during the trial and watched it with my own eyes. A lot of those acts happened during President Trump's presidency in 2017. And so I think it's an appropriate exercise of judicial restraint to go through each piece of evidence and determine which bucket it falls in for presidential action. So it could add a lot of time, not only to this case and the sentencing on July 11th, but also many of the other cases.
At the end of the day, all four cases, whether it's the Georgia case, which is still stuck because of conduct by Fani Willis, or the classified documents case, which seems to be a bit stalled, and correct me if I'm wrong on this, markets person, not a lawyer. But at the end of the day, it does seem like everything is now being pushed past the election, in your opinion? Because some of the polls are showing us that Americans are having the opposite effect that probably the Biden campaign wanted to see with these cases. The polls are showing, in particular after the debate last Thursday night, that more are moving towards President Trump simply because of the bad performance we got from President Biden.
Yeah, Cheryl, and obviously the Biden camp wants a change in the narrative. They do not like this discussion of President Biden's age and faculties. And what's going to happen because of this case, you now insert a whole new appealable process. When a judge in any of these 4 cases has a hearing, that's immediately appealable on the immunity question all the way to the United States Supreme Court if they want to take it. And so, you know, you're right, it's going to add months to each one of these cases, and some of them are already stalled out. For example, Fulton County isn't going to the appeals court on the conduct and the conflict of Fani Willis until October. And so, you know, a lot of these cases are going to take some time.
Real quick before you go, I do want you to listen, before we run, to former AG Bill Barr, who has not been, you know, a fan and has been very critical of his former boss, Donald Trump. Right. But listen to what he said about this decision.
I think this was a very sensible decision that I think most lawyers familiar with this area expected. There's absolute immunity when he's acting directly under the Constitution, carrying out a function under the Constitution. There is presumptive immunity when he performs an official act, and the government has the burden of showing that it can prosecute him for that without impairing the executive function. And finally, there's no immunity for unofficial or private acts.
You know, Matt, what he's saying, the presidency is protected. Any presidency. Final thoughts.
Well, and it always has been. That's the thing Judge Roberts makes very clear, is these traditions and doctrines have lasted as long as our republic.
Matt Whitaker, always a pleasure to speak with you. Thank you for being here.
Thank you, Cheryl.
All right.